one could always find a justice of the peace in St. Louis. These courts functioned as the emergency rooms for persons in transport with legal difficulties. So consider the odds. Imagine a black servant suing that person's white master before a jury and judge of all white men, many of whom were slaveholders themselves. More than 100 times, the St. Louis Circuit Court responded to their claims with those precious words declaring that the plaintiff was forever free from their putative master and all claiming under him. Was suing for freedom a lost cause? Was it a foregone conclusion that the slave would lose in a slave state? What are the odds of success? Surprisingly good. Slaves petitioning for freedom in St. Louis won more than 100 contested cases. Why? Because of a second remarkable feature. The unique Missouri statute enacted during Missouri territorial days and reenacted immediately after statehood specifically enabled slaves to sue for their freedom. With this Missouri statute as its basis, more than 300 slaves had sued before in similar circumstances in St. Louis alone, and the majority usually won. The Scots should have won the case, and easily so, under Missouri law in the Missouri courts. By the numbers, roughly 300 cases were filed in St. Louis involving 239 litigants. Slightly more lawsuits than litigants because some filed suit more than once. I've assembled 170 signatures of these freedom litigants here from the case files that we've been able to discover in the storerooms of the St. Louis courtroom. These signatures were made by persons who were forbidden from learning to read or write by Missouri law, and this was the first time that they had ever held a pen. This is their signature, indicating their agency. More than 100 times, the St. Louis Circuit Court responded to their claims with those precious words declaring that the plaintiff was forever free from their putative master and all claiming under him. For the most part, these freedom suits were family affairs. A total of 160 of the 239 were clustered in 38 identifiable families and housemate groups. So what was a freedom suit, and how did the slave get to court and acquire a lawyer? Under the procedure set out by the Missouri statute, the slave began the lawsuit by orally presenting his or her case before a court official, the clerk of court, a justice of the peace, a judge, or even a lawyer. That affidavit told the slave's story. I tell 12 of these stories in my forthcoming book, Redemption Song, Suing for Freedom Before Dred Scott. The clerk then wrote that story down, and the slave signed with the X customary for illiterate persons. One remarkable feature of the Missouri statute was that such affidavits, if approved, allowed slaves to be declared paupers and to be appointed lawyers by the judges who reviewed the affidavits. Slave freedom suits were unique in this regard in Missouri because no other segment of the impoverished public was given a lawyer by simply filing suit and asking for one. But in this particular Missouri suit, the slave was actually assigned a lawyer. This meant that the slave did not need to find legal representation themselves. If the slave claimed circumstances sufficient to bring a cognizable claim, a judge would assist in finding an attorney for him. Some slaves did approach lawyers who in turn assisted them in filing the affidavit, and other slaves seem to have proceeded to an official on their own. It should be noted that slaves had considerable freedom of movement within St. Louis because such liberty was essential for them to accomplish their master's chores. Fetching water, doing laundry, and running errands routinely took them throughout the city. Thus, it was not difficult for a slave to reach a justice of the peace. If no lawyer already stood with a slave, the judge could assign almost any lawyer, sometimes someone who was just present in court that day, or in other times some lawyer who was routinely assigned these freedom suits.